Bom dia a todos, meu nome é Leonardo Nemer Caldeira Brant, eu presido o Centro de Direito Internacional com sede em Belo Horizonte. É com muita alegria que eu saúdo a todos os presentes, saúdo igualmente os professores internacionais e nacionais que irão estar conosco durante essas 2 semanas, durante o 16º curso de Direito Internacional. Eu gostaria de dizer que, em primeiro lugar, esse curso foi todo desenhado num novo modelo online. Nós já estamos aí no 16º curso desse gênero. Ele foi totalmente adaptado às novas circunstâncias, o que, de certa forma, permitiu também uma extensão do número de participantes, de professores internacionais e nacionais participantes. Temos este ano 19 grandes nomes do direito internacional que estarão presentes conosco durante essas 2 semanas. Num primeiro momento, portanto, eu gostaria de agradecer a todos os professores que colaboraram conosco, que estarão conosco nesse período, com palestras muito interessantes sobre temas dos mais variados do direito internacional. A todos eles, o meu muito obrigado. Em segundo lugar, saúdo e agradeço também aos alunos, aos estudantes que estão participando neste período de julho, conosco durante essas 2 semanas. O nosso também muito obrigado. Esse é um curso que envolve uma grande equipe do Centro de Direito Internacional, a qual eu tenho o imenso orgulho de colaborar e de presidir. Ele é um curso que pretende trazer para o Brasil e para a nossa América Latina o mesmo modelo de cursos que, de forma quase centenária, já é uma tradição nos países europeus e nas principais universidades do mundo. Portanto, para nós, uma grande satisfação que tenhamos ele já há mais de uma década no Brasil. O curso de inverno de Direito Internacional, com toda a sua abrangência e extensão, não seria possível de ser realizado igualmente se não fosse a relevante parceria e a confiança e o apoio da Fundação Konrad Adenauer no Brasil. A ela estendo um caloroso agradecimento e tenho a certeza de que estamos contribuindo juntos para os valores do direito internacional, para os valores dos direitos humanos, para os valores do Estado Democrático de Direito, para os valores da democracia e, com certeza, para a compreensão e construção de um mundo, de um universo internacional mais justo e mais equilibrado. Portanto, agradeço de forma calorosa ao apoio da Fundação Konrad Adenauer no Brasil. Gostaria, portanto, de dar início ao 16º curso de inverno de Direito Internacional, esperando que todos tenhamos 2 semanas de muitas atividades e aprendizado. Um forte abraço a todos.
Good morning, dear colleagues and students. We will begin the second part of Professor Bruno Simma conference on the International Court of Justice and Human Rights. After the lecture, I remind everyone that we will have 20 minutes for the questions that you can post in our chat room. Again, I thank a lot Professor Bruno Simma for his participation in our CEDIN International Law course, and I give him the floor. Professor Simma, the floor is yours.
Thank you very much. Dear audience, I hope you had a good evening and a good night and can stand me for another let's say, hour or so. You will remember that yesterday I started describing the most important human rights cases, or you could say the cluster of human rights cases that were decided by the court since 2010, since 2010. And I started with the Diallo case between Guinea and the Democratic Republic of Congo. And then I mentioned a case that I liked less, but which of course is a human rights case, which is the case between Georgia and Russia on the application of the International Convention on the Elimination of Racial Discrimination, which at the end founded when the court did not find that the jurisdiction was given, so that case did not come to an end on the merits. Now, after this negative, let's say, a milestone, we come to a case which is to be seen in a very positive light. I think it is the first of two cases that are almost too good to be true, against the background of what the ICJ had decided before. And that is a case brought by Belgium against Senegal in 2009. Belgium sued the Senegal on the following basis. There is the African state of Chad, and in that state, a dictator, Habré, had reigned for a decade of years and killed and tortured political opponents, etc. Now, Habré was removed, and he went to Senegal and lived a relatively comfortable life there. Now, both Belgium and Senegal are states members of one of the big UN human rights conventions, namely the UN Convention Against Torture. And this convention contains an obligation according to which every member state has to prosecute or punish persons who are considered or to have committed tortures or other inhumane treatments to people. Now, Senegal did not really take any steps against Habré, and so Belgium came on the fore. The question is, why Belgium? I think Belgium, that we remember that we are going to see from another case, has a special judicial institution, which is the figure of the juge d'instruction, which is mainly essentially young people, very eager. And one of these juges d'instruction in Belgium issued an international arrest warrant against Habré. And Belgium had to take this up. There was political pressure. Actually, some political refugees from Chad had gone to Belgium, had in the meantime become Belgian nationals, and had also kind of made their influence. So the Belgian government really went to the ICJ and said, well, Senegal, you are violating, you're neglecting your obligations under the Torture Convention. You have to either start your own prosecution, or you have to extradite, that have you surrender the person to another state party to the Torture Convention, which is able and willing to prosecute that person. And then they said, if you don't do it yourself, you have to deliver Habré to us, to Belgium. And nothing happened, nothing very much happened. And so things went to the ICJ. And the interesting thing here is, what is the legitimation, what is the standing of a state like Belgium in a case like that? And this was the first occasion in which Belgium relied on something that the International Law Commission had devised about 10 years before, when they dealt with the topic of state responsibility. The articles adopted by the International Law Commission on State Responsibility have a chapter on invocation of responsibility. And there is a novelty there. According to the law designed by the International Law Commission, state responsibility, that is the invocation that another state has breached a rule of international law and is therefore responsible, such invocation can not only happen by states that have been directly injured, but also by what the Commission calls states other than injured states. Belgium put forward the case basing itself on both of these positions. They said, we are, first of all, a state party to the Torture Convention, like Senegal, and every state party to the Torture Convention is entitled to bring a breach to the ICJ. They also invoked their quality as a state other than, as an injured state, because they said, we have asked you to obey with your obligations under the Torture Convention. We have been in diplomatic intercourse that you have not reacted, you have not sufficiently reacted, and therefore we also can consider ourselves to be injured. The International Court decided the case in 2011 and said, yes, indeed, the Torture Convention is a treaty which contains obligations erga omnes partes. You will remember from yesterday, Barcelona Traction, obligations erga omnes, that is obligations, breach of very important norms of international law, like the obligation not to commit genocide, obligations in the human rights field. And these obligations create an entitlement in all other states to invoke the responsibility of the state which is in breach. So, and this invocation, this construction was used for the first time before the ICJ by Belgium against Senegal. And the ICJ took it up and it accepted it. Let me just say in square brackets that both the Russian judge and the Chinese judge were very critical of that construction, but the great majority accepted it. So the court found that indeed the Senegal had violated its obligations under the Torture Convention by not engaging in prosecution of Mr. Habré. And the court also found that the prohibition of torture was a rule or an obligation which was anchored in customary international law. So a very important finding on the sources of human rights law. It cannot only be treaties, it can only be customary international law. That is the Belgium-Senegal case. At the moment, at current, the International Court of Justice is dealing with another case which is similar to that, which is the case brought by Gambia, the African state Gambia, against Myanmar. In Myanmar, you probably have heard about that there were grave violations of human rights, mass atrocities committed by, alleged mass atrocities committed by the Myanmar armed forces against an ethnic group which lives in the most western part of Myanmar, the so-called Rohingya, which led also to mass exodus of people into the neighboring country, Bangladesh. The case or the situation also has a religious background. The majority population of Myanmar is Buddhist, whereas the Rohingya are a Muslim minority. There were UN investigation missions which came out with very, let's say, terrible reports about what had happened, etc. There is an international organization, the Organization of Islamic Countries, the OIC. And the OIC got together and the state of Gambia took the lead. Very interesting, because until very recently, Gambia was under a dictatorship with a lot of human rights violations happening. But this dictatorial regime had been removed and the new government was a liberal government and very human rights friendly, and especially the Attorney General and ministers, etc., of Gambia took a keen interest and were very concerned about what happened in Myanmar. And so Gambia went to the International Court and claimed that by the Myanmar called clearance operations, Myanmar committed acts of genocide. So it's another genocide case. But different from the genocide cases, Bosnia against Serbia, Croatia against Serbia, this case was not brought by a state deeply involved or the victim of the genocide, like the Bosniaks in Bosnia-Herzegovina, the Croats, but by a state where again the question arises: what is the entitlement? What makes Gambia a state legitimately claiming the commission of genocide by another state? And again, the same construction is at the basis of that claim, that the modern law of state responsibility entails the possibility for a state other than an injured state to invoke the responsibility of a wrongdoer for breaches of obligations which are erga omnes, universally, or erga omnes partes, partes standing for parts or parties, that is, states that are parties to one and the same treaty. A few months ago, the International Court of Justice rendered a provisional measures order which obligates Myanmar to desist from these human rights violations, from violations of international humanitarian law, and which obligates Myanmar to make periodic reports to the court indicating what steps they have taken to prevent these acts from being committed. These measures were adopted unanimously, which is really a remarkable achievement. Now, of course, the case enters the stage of the finding or the decision on jurisdiction, and Myanmar will certainly fight against jurisdiction by the court by all means. My prognosis is that the court will find that it does have jurisdiction on the basis of the Genocide Convention, because if you look at the Genocide Convention, it's quite clear. Every member state of the convention is entitled to bring a case to the ICJ if there is if there is a dispute. The dispute is there between Gambia and Myanmar because Gambia engaged in diplomatic exchanges with Myanmar about the matter. That was sufficient for the court to find that there is a dispute between the two countries, and there is a legal standing on the part of Gambia. But of course, the decisive question will be, okay, once jurisdiction is accepted, we reach the stage of the merits, and what is the court going to find about the merits? And that is a very, 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 very big benchmark to pass, because I think, as I mentioned yesterday, and I'll mention that today, the pattern of, let's say, mere state behavior, patterns of state behavior as such cannot establish or the commission of genocide. What is necessary for the court to find a commission of genocide is that these acts, whatever mass violations, massacres, ethnic cleansing, that these acts are done with a special intent, a dolus specialis, and that the special intent is more or less the annihilation of a group, the extinction of a group. Now, you will remember in the genocide cases concerning the Balkan Wars, the court came to the conclusion that, with the exception of Srebrenica, all the other violence that happened there, and the entire violence committed by Serb troops against Croats, did not amount to genocide. They were crimes against humanity, and the aim, the purpose of these violations was to shock, to deter the population on the ground and make the population flee to a neighboring country. And of course, that is, according to the ICJ, that is not genocide. It's ethnic cleansing, but ethnic cleansing alone is not genocide. And so if you really ask me what is the outcome that I expect from the in the Gambia Myanmar case, I would say, unfortunately, I think the court will not be able to find that special intent. There is one element which makes things even more difficult for the ICJ in the present case than in the Yugoslav cases, and that is the non-existence of an international criminal tribunal. Of course, this international criminal tribunal was there in case of the war in Yugoslavia, and of course, this international criminal tribunal had the prosecutor's office in that tribunal had engaged in massive fact-finding, and so the ICJ was able to base its own findings on what the ICTY, about 1 kilometer away from the ICJ, from the Peace Palace, had found in that regard. In case of Myanmar, no such international criminal tribunal is underway. There is at the moment, there is no claim or no project to create such a tribunal. And as I said yesterday, the ICJ is more or less not capable to engage in its own independent fact-finding. So what they can do is can rely on UN observer missions, on UN investigations, which of course a reliance on such third-party observations, etc., is very problematic as a method of proving a certain activity. So I would love to lose the bet, but I think that the court will not lead to a finding of genocide. But of course, politically speaking, for Gambia, even if the court does not find genocide, Gambia has there is going to be a lot of public attention on the case, and that of course is a purpose of its own. Just one little element of anecdote at the end. The Gambia versus Myanmar case is the first case in which social media played a role, because a lot of the evidence that the UN found about the involvement of the Myanmar army, the activities of the army, was the Facebook accounts, or let's say messages that were sent by the Myanmar armed forces by Facebook account. The Facebook accounts have, in the meantime, being shut. I'm not on Facebook, so I don't know how it works. But they said the accounts have been closed. But a few weeks ago, actually, I got an email from a U.S. law firm, and they said, Professor Simma, would you write us a legal opinion on that question, because we are working for Myanmar, and the purpose of that opinion, or the aim that would be that it makes no sense to allow document production into Facebook accounts, because everything that Facebook messages can provide is already on the file. And of course, you can imagine that I said, no, thank you very much. I'm not going to do that. That much on Gambia against Myanmar. Now, at the end of this, let's say, investigation of human rights cases by the ICJ, let me turn to a special category of cases. These are cases in which one state bases its claim, among other things, on human rights. These claims are countered by the respondent state by arguments which are based on more traditional international law. And the court makes its decision, and the decision is not in favor of human rights, but the respondent wins the case by relying on the more traditional rules. And these are cases that turn around state immunity or immunity of state organs. That is, one state brings a claim against another state, and says you have breached the rule of international law. I'll get to the concrete cases in a second. The other state says, yes, but that act, that statement was done by a state organ, a minister of mine or somebody, and therefore that person enjoys immunity. We enjoy state immunity, jurisdictional immunity from before the courts of another state, and therefore what you have done is not permissible. There are two cases around in that regard, and the first case is the so-called arrest warrant case or Yerodia case. And again, we are in Belgium. Again, we have these eager human rights, eager juges d'instruction. What has happened? In the Democratic Republic of Congo, you remember the country from the cases I mentioned yesterday, had problems with its neighboring states. The neighboring states had entered the country with the consent of the DRC government, but in order to quell unrest in the country. But once that, let's say, the situation had been more or less brought to an end, these countries did not leave, because apparently on the territory of the Democratic Republic of the Congo, you find many things and resources that you would like to have for yourself. So they didn't go. And in that situation, a minister, the minister of the Democratic Republic of Congo, engaged in public speech in which he said, let's get rid of the Ugandans, let's get rid of the Rwandans. They are our enemies now, and go out and drive them away, and if necessary, kill them. And that was regarded by this Belgian juge d'instruction as a violation of international law, that is sort of called excitement to genocide, excitement to other human rights violations. And he got an international arrest warrant against that minister, Mr. Yerodia. And the Congo went to the ICJ and sued Belgium. And the ICJ found that indeed Mr. Yerodia, as a minister, enjoyed absolute immunity for what he had said. And therefore, the arrest warrant brought by Belgium against that person was a violation of the right of the Congo to see that its organs were not subjected to foreign jurisdiction. That the organ immunity, agent immunity, state immunity. That, of course, is typical. I mean, a human rights claim is countered by a claim based on traditional international law. And what that case shows is that the ICJ does not always decide in favor of the human rights arguments. There is one passage in that judgment which I'm going to read to you, because the court said at the end of that very unsatisfactory judgment, in my view, he said that immunity from jurisdiction enjoyed by incumbent ministers for foreign affairs does not mean that they enjoy impunity. That means immunity does not imply impunity. And then they say, because there are a number of conditions under which such persons can be sued before courts in other countries or before international criminal courts. And one of these instances, which the ICJ found, was a sign that no, there is no impunity. There is still a possibility to punish such people. Is phrased as follows, and I'll read that. The court said, thirdly, after a person ceases to hold the office of Minister for Foreign Affairs, he or she will no longer enjoy all of the immunities accorded by international law in other states. Provided that it has jurisdiction under international law, a court of one state may try a former Minister for Foreign Affairs of another state in the respect of acts committed prior or subsequent to his or her period of office, as well as in respect of acts committed during that period of office in a private capacity. Now, of course, if we had a seminar with back and forth between us, my question would be, do you see a problem with that formulation? And I'm sure you would raise your hands and say, of course, because what is with acts committed by a foreign minister which is in office, committed not in his private capacity, but in the capacity of being a foreign minister or a minister of justice or head of state or whatever. And there the court makes no exception. It says the court does not, and you could say in a sense, the court does not recognize that such violations of human rights can be committed by persons in their official capacity. Because if you ask a country, has your foreign minister or has Mr. Committed has he, let's say, was there excitement to genocide or propaganda, etc.? They will always say, we have not done this. This is not done. And if somebody said something, he or she did that in his or her private capacity. But of course, the people don't do these things in their private capacity. They do because they are in a public office and they have the power, the authority to come with it in order to engage in such breaches of international law. So that is a very important lacuna in arrest warrant. And I remember when I was at the court, and then we started dealing with the Congo-Rwanda case, Judge Rosalind Higgins came to me and said, Bruno, this time we human rights lawyers on the court, we have to kind of rally together and see that judgments similar to that don't ever happen again before the ICJ. And that then led to this joint dissenting opinion against the finding of the court that unfortunately the reservation made by Rwanda excluding the jurisdiction of the ICJ was valid, so the court couldn't do anything. So the arrest warrant case is a very good example of let's say the victory of old-fashioned international law over claims on human rights. And the second case, and the last case on my list, is a case brought by Germany, that is my home country, against Italy. What had happened was that Italian courts, among them the highest court, the Corte di Cassazione, had rendered decisions which found Germany, the Germany of 2010, 2020, responsible for violations of human rights and violations of international humanitarian law committed by the SS, the Gestapo, that is armed forces of Germany from 1943 to 1945. Italy had begun in World War II as an ally of Germany, but in 1943 it had turned to the other side. So Germany kind of occupied the rest of Italy, and the German troops engaged in fighting the partisans, vice versa. So terrible things happened also there. These cases were brought before Italian courts, and in the 1990s, the Italian courts, early 2000s, the Italian courts found that Germany had indeed engaged in these violations, that this led to responsibility by Germany. Germany had not done anything to compensate the victims of such crimes, and therefore would Italy please go ahead and claim compensation from Germany. Germany regarded these court decisions as breaches of the old established law, again, jurisdictional immunity of states, which means that no state can be brought against the domestic court of another state for acts that are not more or less of a commercial nature, the iure gestionis, but acts committed iure imperii, of course in square brackets, to describe war crimes, crimes against humanity, by the nice Latin title, Acts Iure Imperii, is a bit too much of a compliment to these activities. But the courts, and so Germany The same things actually happened in Greece. There were cases of where the German armed forces during World War II had massacred entire villages in Greece, were brought before the Greek courts. The highest Greek court rendered the decision and said, Germany does not enjoy, cannot rely on immunity for these acts. Then Germany, of course, there was diplomatic pressure, as you can imagine. And then through things that are a bit too complicated for me to really set out in detail, brought these cases to an end in Greece. And so the Greek claimants brought these cases, the judge and judgments rendered by the Greek courts before to Italy. How is this possible? Well, this can be done on the basis of European Union law. There are rules in European Union law whereby a judgment rendered, let's say, in Greece can be more or less executed, brought to execution in another member state of the European Union. So they went to Italy because they had learned that in Italy there was the same jurisprudence, and so Germany complained about the position of the Italian courts and the recognition by Italian courts of these Greek judgments that all went against the state immunity of Germany. Now, remember at the time there was a huge, let's say, expectation of the human rights community that there the International Court of Justice would have an opportunity to really come out in favor of that new international law of human rights against the state immunity, which Germany did not deserve in view of the crimes that Germany had committed in the 1940s. The ICJ had jurisdiction on the basis of a European Convention on the Peaceful Settlement of Disputes. And according to that treaty, the jurisdiction on the basis of that convention extends to, let me read it because this is, there's the question for jurisdiction with regard to time, jurisdiction ratione temporis. And there the convention says, the convention, and that is the jurisdiction of the ICJ, is not given for disputes relating to facts or situations prior to the entry into force of the convention as between the parties to the dispute. Now, the convention had entered into force between Italy and Germany in 1961 only. Well, the convention was adopted, concluded in 1957, so 1961 is not really bad, 4 years after. But the important thing is you can only bring acts before the ICJ, which had facts or situations before the ICJ that had occurred prior to the entry into force, that is prior to 1961. And that meant that a lot of the things that the human rights community thought would end up before the ICJ and would be regarded as crimes and would be decided against Germany were not under the jurisdiction of the court. Namely, the question of the German war crimes, the crimes against humanity, the question of the duty of reparation arising from these crimes. The question, is there not just a reparation claim between at the level between the two states, but also claims to compensation by the individual victims of such crimes, the effect of comprehensive waivers. Actually, after World War II, Italy had declared a waiver and said, we are not going to claim reparation from Germany, among other things, for what they have done in our country, etc. That was not under the jurisdiction. So all the court could decide were what had happened after 1961, more or less meant the court had to decide about the behavior of the Italian domestic courts as such. not the reason why the Italian domestic courts had arrived at these conclusions in before. So the court went into a comprehensive study, really a very thorough study on the question, what is the state of international customary law on the matter? And it came to the conclusion that international customary law had was originally based on a comprehensive state immunity for acts committed by state organs in their as acts of public authority, iure imperii. And the court found that even though there were court decisions here and there around the globe, there no, let's say, practice, no general practice accepted as law had developed and had more or less eclipsed or done away with the traditional principle of immunity. In that regard, the court is founded the finding on what the International Law Commission has also found a few years, also while I was a member of the International Law Commission, that there is a UN Convention on Civil Jurisdiction Immunity of States. I think it's adopted in the early 2000s. That the European Convention got some kind of a second reading by the International Law Commission while I was there as a member of the Commission. And one of the questions before the Commission was, is there a new exception to state immunity for grave human rights violations? And the International Law Commission did a thorough study and came to the conclusion there are certain trends, but there is no universal trend yet. The cases where domestic courts have accepted states from immunity due to war crimes, etc., are rare. So the general customary law in favor of state immunity still exists. The ICJ has to render its decisions on the basis of Article 38, which is on the basis of treaties, customary law, etc. And the court had to decide, according to the customary law, that we have to apply. There is no new exception in customary law or anywhere else that we have to accept, that we have to respect. So the court said there is no exception due to the gravity of the violations. There is no exception due to the character of the prohibition of war crimes, etc., as use cogens, as peremptory rule. There is no exception simply because the recourse that these Italians had to their Italian courts was the last avenue, the absolutely last means to maybe arrive at the remedy. All that did not impress the ICJ, and it came out in the judgment as saying Italy has violated international law vis-à-vis Germany by the activities of its, or by the pronouncements of its domestic courts. And Italy has, by way of means of its own choosing, repaired that situation. So great outcry in the human rights community worldwide. Great relief, I have to say, with a little sarcasm, in the foreign offices among the diplomats of not just in Germany, but also in Italy and in other countries, because if the court had decided otherwise, in case of Italy, what would have become problematic would have been the Italian activities or behavior in Ethiopia in the 1930s or against Libya, where Italy had engaged in all kinds of crimes itself. But one interesting, or let's say, thing happened afterwards. In 2014, the Italian Constitutional Court found that the Italian Constitution obligates the Italian state to respect and ensure the basic human rights of its nationals. The Italian courts had actually acted in, let's say, in that respect. But the Italian state had declared that it would oblige, that it would implement the judgment of the International Court of Justice. And that act of implementation was a breach of the Italian constitution, the very fundamental human rights of the Italians, according to the constitution. And so the court said, if even found that the law, the Italian law by which Italy had incorporated into its domestic law the UN Charter, the Charter of the United Nations, that this Italian law was unconstitutional if Italy read the provisions of the UN Charter saying that decisions of the International Court of Justice rendered against Italy have to be performed. If such implementation were to extend to the judgments like the one they had rendered with regard to German war crimes, that would be a violation of the Constitution. Just a judgment which has created a lot of, let's say, a huge echo. I remember I a few years ago attended a conference on Lago di Como, Lake Como, because there's a beautiful villa there, Villa Vigoni, which belongs to Germany. And the Italian courts had already sort of selected Villa Vigoni as the German property into which their judgments on the responsibility of Germany for these war crimes would be executed. And at that, well, okay. I think, again, I'm running out of time if I go into details there. So much the jurisprudence of the ICJ. And now let me more or less come to the very last part of my lecture, namely what, after all these cases that we have heard, what is to expect? What are, do human rights really have a chance before the ICJ? Is it a good idea to bring these cases before the ICJ? If you bring such cases to the ICJ, what are limitations, what are obstacles, and the like? So let me just spend a few minutes on these matters. And I think most of these observations will be rather in the nature of sobering remarks. That is, don't put your expectations too high. Because, and I have 4 points to make here. The first point is, I would like to again emphasize the principle that the court's jurisdiction is not compulsory. It has to be established in each concrete case by an agreement of the parties. Now, if you look at the human rights conventions, the human rights treaties, let's say concluded by the United Nations, as the main bulk of human rights law that might end up before the court, you see that only a handful of these treaties provide for the jurisdiction of the ICJ. And there's only one human rights treaty which provides that states can go to the ICJ immediately. In the other few instances where the ICJ jurisdiction is provided, before you can go to the court, you have to engage in certain steps. And if you don't, let's say, if you don't set these steps in a sufficient way, then recourse to the ICJ is out. And you will remember the Georgia v. Russia case, in which the court found precisely that, namely that Georgia went to the ICJ, but did not beforehand engage in sufficient negotiation or attempts to settle the case peacefully with Russia. So, and of course, this is really an element that will be very important. That it will be very difficult to, let's say, find a human rights treaty which provides everything that you need in order to succeed with a human rights case. Gambia against Myanmar, Genocide Convention. Positive or opportune in the sense that it enables a country to go to the court immediately. But of course, the big problem with the Genocide Convention, as I've stated repeatedly, that genocide needs that you prove that special intent. And in my view, the chances of winning a case on the basis of a claim to genocide by the other side is minimal. Therefore, because you had Srebrenica, but that was only a very, very small fragment, let's say, brought before the court by the claimant states in the Bosnia and Croatia cases brought against Serbia. Second point, human rights violations. Human rights violations before the ICJ. Cases or contentious cases before the ICJ can only be brought by one state against another state. And in a way, we are looking at the wrong relationship there, because human rights violations viewed from the angle of another state can only bring to the fore very limited aspects of these problems. The court will look at human rights violations from the viewpoint of state responsibility. You read in the statute of the International Court of Justice, you'll see that questions of state responsibility are questions that you put forward. For the court, human rights violations are matters of state responsibility. If you look at the law of state responsibility, it has been modernized by the International Law Commission to some degree. But if you look, for instance, at what the general law of state responsibility applicable by the ICJ, what that law provides with regard to human rights violations, you will come to the conclusion that it doesn't provide anything, especially, let's say, tailored for human rights violations. What is the general law of state responsibility? The general law on remedies, it's satisfaction or reparation. Reparation in the form of compensation, that is, you pay money. It's let me say, compensation or restitution in integro. These are all remedies that are, you can see, have their basis in good old tort law. But tort law is not the ideal means to come to terms with human rights violations. If you compare what the ICJ had to say in the genocide cases on the possibility of remedying these violations, if you compare that with the jurisprudence of the Inter-American Court of Human Rights, for instance, where they really create bespoke remedies, or there are famous declarations by the UN General Assembly on compensation for human rights violation, etc., etc. You see that the ICJ has to work with a set of instruments in that regard, which is old-fashioned, which is tailored for relations between states. If Austria breaks an obligation against Germany, there will be an excuse, there will be compensation, there will be made more or less reinstatement, etc. But that doesn't help in case of human rights violations. The third point, states will very rarely actually engage in bringing human rights violations by other states before the International Court of Justice. Just read the newspapers. I think yesterday I mentioned the example of Hong Kong. If you look at the European Convention on Human Rights, for instance, which provides also for state applications, that is, according to the European Convention, only states can bring cases against other states for human rights violations. If you look at these cases, what you find is, first, they are very rare. Individual complaints, they go into the hundreds of thousands. State complaints are less than 2 dozens. Why? Because states simply, to bring to bring the human rights violations by states before an international court or before the United Nations, in almost all instances, presupposes that there is a special situation around that, or there is a special relationship between engaged here. For instance, the very first state application, state-to-state case brought on the basis of the European Convention was a case brought by Greece against the United Kingdom, and it had to do with Cyprus. And of course, you see, okay, Cyprus, majority population Greek. What did Greece complain about? Complained about the treatment of Cypriot freedom fighters against the British before Cyprus was released to independence in around 1960. So the British fought the freedom movement on Cyprus, and Greece took up that case. Or you might have heard about the cases brought by Ireland against the UK in the 1970s due to there was this, let's say, civil war almost in Northern Ireland. There was very, very, let's say, forceful combat against by the British armed forces in Ireland. And so Ireland brought a case claiming that the British armed forces had engaged in torture, etc., of Irish freedom fighters. So in almost all cases, you find an element, I'm claiming human rights violations in another country, but if you look closely, you see these are they belong to the same ethnicity. Greek case. They are Irishmen like we, Ireland against United Kingdom. And also in Gambia versus Myanmar, you see the link of religion. Gambia, as a country with a Muslim majority, goes against a country with a majority population which is Buddhist, and the violation is breaches committed against the Islamic minority, to which you somehow feel have a certain relationship. And it's very, very rare to come across a case which is, you might call it a pure human rights case, in the sense there is no traditional element of allegiance or alliance between the victims of the human rights violation and the state going to the ICJ. Maybe Belgium against Senegal in that regard is even quote unquote purer than the Gambia against Myanmar case. And the fourth point is very simple. Before the ICJ, states make claims, and the International Court of Justice has to be very careful not to step beyond, not to go beyond in its decisions over beyond the claims of the parties. You will have heard the saying, ne eat judex ultra petita partium. And so whether human rights claims will be made or how forceful they will be made will all depend on the state's parties. And the court is, in that sense, is in the hands of the state's parties. And states are, for a number of reasons, not really keen, except if you go against a political opponent, you want to hit that state with every argument you have. And you say, and besides, number 7, the guy is also a very bad human rights violator. So that's all very negative. But so isn't there something more positive to say? And of course, positive things are there, namely, the human rights genie is out of the bottle, so to say. I mean, you have more and more human rights law. Human rights considerations permeate let's say, are visible in more areas of international law. And so I think it will just be inevitable, unavoidable, that you will have human rights cases also in the future. So human rights arguments will continue to be made. And maybe a special observation ought to be made here with regard to advisory opinions. I have really focused on contentious cases until now. But of course, I've also mentioned, and a lot of the cases that I have mentioned have actually been not contentious interstate cases, but advisory opinions rendered. And in advisory opinions, the court is much freer and it can refer to law, it can apply law, even though the parties, and of course, sorry, you don't have parties in case of an advisory opinion, but you have states which appear. For instance, in the Wall opinion, I remember there were scores of states appearing before the ICJ and pleading, not as parties, but just as every member state of the United Nations can go before the ICJ in a proceeding on an advisory opinion and state its view. And many states do. But even arguments that are mentioned by neither of these states can be, let's say, used by the court in advisory opinion. The court will be very careful in this regard, but it's not something that must not be done. And so my expectation would be that it will be particularly in advisory opinion proceedings that the court will make let's say, strong statements on human rights matters. And then the last question will be the following. Is there something, I mean, we have now a whole series of international organs, of international institutions, of international courts dealing with human rights matters. You have regional courts, particularly regional courts, Inter-American Court, European Court, African Court, and then you have the ICJ. Is there some kind of consequence to draw from that state of affairs? And I think one thing that we should conclude from this is that the court should be very cautious in the field of human rights, because you have a large and very, let's say, thorough and very carefully crafted jurisprudence of regional human rights courts on almost all basic human rights. And if somebody steps in from the sideline, as the ICJ, willing to also engage in human rights discourse, that the ICJ will have to be very careful not to lead to, let's say, to a lowering of a standard which has been achieved at the regional level. So one could say that engagement of the ICJ with human rights is a bit of a double-edged sword. It brings, on the one hand, it brings recognition and respectability to human rights within the mainstream of public international law, but on the other hand, it may also do so at the cost of curtailing the substance of international human rights law that was established and fought for by regional human rights courts. And I think the court is actually very careful in that regard. It is conscious of that problem. So what then is a proper role for the court? Something that the court can do better than other courts. And in my view, there is such a proper role to be found, namely in what I call the juridical mainstreaming of human rights. Human rights, that is, the ICJ is an organ which is, let's say, singularly capable of mainstreaming human rights in the sense of integrating this branch of human rights law into the fabric of general international law. So the court, you could say, human rights claims arise in very different ways. And at some stage, they are claimed also in legalistic terms. And maybe human rights claims will find will have an impact on, let's say, general comments of UN human rights treaty bodies. I've been engaging in devising such general comments for 10 years in my Committee on Economic and Social and Cultural Rights. But when you look at these general comments, they're very valuable and they have a high authority, but it's very difficult to say, for instance, you have a general comment on the right to water, on a core obligation with regard to social security, etc. To see now what is precisely, is this all the law? If they set out something which in the human rights treaty is written down in one sentence, and the general comment comes out on 5 typewritten pages. Is this all supposed to be the law? Is this an interpretation? Or is it something that these bodies kind of attach to a core international legal obligation proper? And in that regard, of course, let's say borders are very, very difficult to draw. But you could say that once the ICJ has taken up such a human right and has defined what it contains, has determined the limits, you could say this provision of human rights has gotten, let me call it, the ultimate blessing from the viewpoint of international law and the appliers of international law. And one special group in that regard would be when the court finds, let's say, solutions for practical, more technical problems arising in connection with human rights. For instance, I would consider a decision by the International Court would be very valuable with regard to the problem of reservations to human rights treaties. One of the big, let's say, very fashionable topics in recent years, reservations to human rights treaties. We have International Law Commission work. Part of that law of reservations is quite controversial. And if you had a word by the ICJ in that regard, that would be extremely helpful. So, final statement. So if you wanted to find a short-term description of the current status of human rights before the International Court of Justice, one could say this is an instance of international legal discourse in which the old international law, represented for our purpose by the court, encounters the new international law, which is the law of human rights. And what we can observe already is that the court has become a major player in a process in which human rights and general international law mutually impact upon each other. Human rights modernizing international law, but international law on its part mainstreaming human rights law. Thank you very much. I'm ready now to answer questions. I thank you for your attention. So let's see what we have by way of questions.
Thank you, Professor Simma. I thank you very much for giving us an instigate overview about the jurisprudence of the ICJ, answering the question of what proper role the ICJ should have in human rights issues, what the ICJ must be able to do better than specialized courts. As Professor Simma said, the task of the ICJ is not easy. Its compulsory jurisdiction depends on states. ICJ was created precisely to settle interstate disputes. Only states can sue each other before the court. And of course, it's not surprising that in the past, some of the court's most important contributions to international human rights have been made through advisory opinions. But as Professor Simma concluded, the ICJ can render human rights arguments more, how can I say, acceptable to international law generalists by interpreting and applying provisions of treaties in a way that states can accept. Now we come to questions. We have just 20 minutes, and I will pick 3 questions or just one at the beginning to be answered at a time. The first one is from Fernando Porto de Sá. Professor Simma, even today, we see little dialogue between the ICJ and regional courts. For instance, the Inter-American Court on Human Rights, even when both deal with very similar themes, like in the consular rights case. Should the court, the ICJ, be perhaps more proactive in bringing in not only human rights rules, but also judicial practice into its judgments? Professor, the floor is yours.
I think the question can be divided up actually in two separate questions. The one would be is what kind of connections or discourse or do we have between the ICJ and human rights courts, which are by nature regional, and the second would be judicial practice in a wider sense, right? Okay, let me try. Well, maybe the first thing to say is that the International Court has been very, how should I say, selective in choosing dialogue partners. Actually, until very recently, it has been so selective that it didn't engage in dialogue with any other organ. Let me see, maybe I mentioned yesterday that little anecdote when maybe I can put it in a bigger context so it becomes visible what I mean. This was the case of Congo versus Uganda. And in that situation, what you found was that armed conflict only went on in one region of Congo, namely in the northeast of Congo. And so but certain things happened in Kinshasa, which is at the other end of Congo, namely at the Atlantic Ocean. And there's, I think, 1,500 kilometers in between. And so the question was, now, if you have to apply rules of international humanitarian law in the war zone, are these rules also to be applied in Kinshasa, when you don't hear any gunshots and etc. And I had found a beautiful case by the ICTY, which had come to the conclusion, well, if armed conflict only, let's say, affects a part of the territory of a country, the law of armed conflict will apply in the entire country. And I was very proud in a drafting committee, and then I was told by the registrar, by the former registrar of the ICJ, who looked at me and said, well, Mr. Simma, we never referred to other international courts. Why? Because, and now I kind of speak for the court in a sarcastic way, because we are the oldest court. We are the principal judicial organ of the United Nations. We are the world court. Therefore, we are the most important of these international courts. And what do we care about these minions, ICTY, ICTR, or even ICC? Courts that more or less were established by a resolution of the Security Council. Look at us. We are really the first rate. It's about like the European Court of the European Court of the European Communities, which is almost biblical and says, "Thou shalt not have another God beside me." And that is also a bit more modestly the position of the ICJ. Don't quote me when you meet colleagues, or don't quote me to Professor Cansado. But there is a bit of that there. And this only changed very, very, let's say, gradually and hesitatingly in the Yugoslavia case, because there, with regard to Srebrenica, etc., the ICJ found I have no separate own means to engage in fact-finding. So I really have to accept what these people up there in this lower court, ICTY, have found. So, okay. Then I remember there was a meeting we had with judges from the European Court of the Court of Justice of the European Communities in Luxembourg. There was a meeting, and it had to do with the problem: to what degree is the European Union a legal person in public international law, and to what is it bound by Security Council decisions, etc., etc. You might have heard the term CADI, the CADI problematic, where the European Court of Justice said, we are not going to admit the effect of certain sanctions by the UN Security Council if these sanctions affect an individual within the European community in his or her basic human rights. So the ICJ will be very, very careful in that regard. There was another case, actually, that almost made it to the court. It was a case brought against between Switzerland and Belgium, which had to do with Sabena, with the Belgian airline. And the case was finally kind of suppressed because the European court would have had to take up questions of European Union law, European Community law, and therefore the European Community, and especially the EC Court, the European Court of Justice in Luxembourg, was not interested at all in some competitor in The Hague taking up questions on which it claimed to have the last and decisive word. So, which means the lack of intercourse, the lack of discourse between international courts, also has to do with what you could call every court has its own turf, and every court is very, very keen on protecting and preserving its turf. There are questions of the, let's say, a relationship, the hierarchy, the rank between certain regional institutions like European Union and public international law. So decisions by a court belonging to one group on the law of the other group might be problematic. This might have political repercussions. Sometimes it's also very personal. I remember I have a good friend who is a member of this is not a regional human rights court. It's the German Bundesverfassungsgericht, the German Federal Constitutional Court. And I have a good friend there who is a judge there. He was my assistant, Andreas Paulus. So I said, "Hey, why couldn't we engage in a visit? Either we come to you or you come to us." And he found that a good idea, but then he came back to me and said, "Well, unfortunately, I spoke with our president and there are problems of protocol. Who should invite whom? Would it be, if you invite us, would that mean that you more or less very grandly invite us as a lowly creature, etc.?" So nothing came out of that visit. So there's a lot of very, how should I say, human psychological reasons there also. You have the European, I don't know about the Inter-American Court. Of course, I'm closer to the European Court of Human Rights in Strasbourg, and they are proud on decisions on questions of general international law. And I would say, I have done a little studies of these questions. You would say there is no real, let's say, a difference, or there is no problem to see in the way in which the two courts look at international law. Strasbourg looks to The Hague, and in the Diallo case, The Hague looked at Strasbourg. There will of course be more opportunity for the Strasbourg court, or maybe also for the San Jose court, to look to The Hague, because they will more often deal with questions of general international law surrounding their conventions than the ICJ will have with regard to the European Convention proper. Actually, also in square brackets, there is some kind of a consensus among European countries that they, especially members of the European Union, that they should not, if not really necessary, should not bring cases they have against each other before the ICJ, because that would be something against that the appearance of the European Union member states as forming a very, very, let's say, intense group of states that you need. Do we need the ICJ, to which Myanmar, Mali go? Do we need them to settle a dispute between Austria and Switzerland? Rather not. So maybe these are things that come to my mind with regard to that, the first part of that question. Should the court base itself more on judicial practice? Now, if the person who asked that question understands that in a certain sense, then I've already answered it. That is, should the court, let's say, take into consideration the judicial practice of other courts? that I have dealt with. And maybe I'll just formulate another bottom line. I think such engagement with the jurisprudence of other courts is slowly increasing. Maybe not as a question, as a matter of love and affection for other courts, but just out of necessity because of the growing specialization of international law. There's a general court, a generalist court like the ICJ, will simply not get around referring to what more specialized regional courts have said about certain matters. So I hope this is a not too exhaustive answer to that first question.
Thank you, Professor Simma. And the second question is from Fabio Farinella. Dear Professor Simma, do you think that a violation of a jus cogens human rights extends its effect to the procedural norms that are used to protect it, and therefore no reservation related to jurisdiction or immunity could be recognized by ICJ?
So if I may kind of turn this question around a little bit and put it into my own words. So it seems to be, so you have human rights, and you have dealt with human rights for 3 hours almost now. So what do you mean when you say erga omnes obligations are rising from it, or human rights norms are being have the nature of jus cogens, which is peremptory rules which cannot be contracted out from, etc. Or the alternative view would be, would we have to distinguish between a core of human rights, and maybe you could determine that core of human rights by looking at the provisions in human rights conventions, like Article 27 in the American Convention, or I think it's Article 4 in the European Convention, which deal with states of emergency, and then say states may, in emergency situations, say that we are going to suspend the granting of these rights under some international supervision, with the exception of obligations 1, 2, 3, 4, like right to life, etc., etc. Wouldn't that be some kind of a sign or a marker of the jus cogens nature of these rights? And I think indeed that is a very pertinent question. I think there is quite a bit to that you see, if you want to find the core human rights obligations, look at these state of emergency provisions. Hopefully you will find them, but not very few conventions. For instance, the Torture Convention does not have provision of that kind. But of course, you find in the General Convention, you find a prohibition of torture. But then, does that really extend into the nooks and crannies of a human rights obligation, or is there some kind of a core and some margin around? And of course, I think that is a very important question. In the very first paper I wrote in my life on breach of treaties, I mentioned an example stemming from IHL, according to which in the treaty law, on probably also customary law nowadays, on the treatment of prisoners of war, there is an obligation that a prisoner of war has the right to write. I think in some could have been an earlier convention at the moment, to write a postcard every 2 months to his family, and that postcard will be actually brought to the other side in the war, etc. And now let's say that the state decrees that, well, instead of being entitled to write such a communication to one's family every month, you're only going to have that right every 3 months. Would that be a violation of a jus cogens, of the jus cogens content of that human rights rule? Second approach to the problem. I remember I had to do with the German Foreign Office for a number of things, more or less on a frequent basis. And I remember sometimes you had people from the Ministry of Justice sitting around the table and discussing matters. And there were times when especially the Ministers of Justice and the Ministers of Interior were quite furious about the jurisprudence of Strasbourg organs. For instance, on matters of, is there a limit to penalties rendered in case of road traffic violations? So if you read some of the jurisprudence of Strasbourg organs, you think, oh my God, I would love to have these problems. The problems Western Europeans have. Look into these details. That is, human rights is kind of settling down into areas where you would never assume that human rights have a place. I remember there was a famous case, one of the leading cases in European Convention law. I think it was the Tyrer case, which had to do with punishment that was meted out on the Isle of Man, which had to do with birching. People were beaten by birches. I mean, I think the Finns do it as a matter for pleasure in their saunas, etc., but most people wouldn't like it. And the then British judge in Strasbourg kind of cried out and said, is this a matter of human rights? Listen, human rights, this is when at 3 o'clock in the morning, somebody, let's say, opens your door with their feet and drags you out of bed, and then you are never seen again. This is human rights, but not these ridiculous things. And of course, he was wrong. I mean, in the specific case, but the question, I think, is a legitimate one. And so my answer to the question put by our student would be, I think you need to distinguish between a core of human rights, and you can only, let's say, put all these qualities like Hughes Kogan's erga omnes, etc., on a core. But please save me to determine the core, aside from the, let's say, observation like state of emergency provisions as a marker, etc., etc. I think nobody has come to a clear distinction in that regard. But fortunately, at the international law level, the human rights, fortunately or unfortunately, actually, that come up at the international level before courts, etc., are very massive, very flagrant, very, very, let's say, grave violations of human rights, where that question does not play a role.
Thank you, Professor Simma. I think that we have enough time for just one question. What do you think? Okay? Okay, sure. So I choose just one. Professor, a question from our student, Leticia Hartel. Professor Simma, could you comment on the possibility of having a judgment by the ICJ clash with a judgment by a human rights court, such as what could have happened in the case certain property Liechtenstein against Germany? What will be the consequences of such a scenario? Our last question.
Mm-hmm. So I'm not sure whether the entire audience, most people stemming from Latin America or Brazil, are very familiar with the Liechtenstein certain property. So this had to do with what happened in Czechoslovakia at the end of World War II, when the people of German ethnicity were evacuated, had to leave the country, and German property was confiscated by the Czech state. One of the people suffering from this was the Prince of Liechtenstein, I mean, they claim that they have their own country, they are a sovereign state, which they are, but the Czechs regarded the Liechtenstein family as persons of German nationality, and they lost their property in Czechoslovakia. Now, years later, some lawyer of Liechtenstein discovered that the paintings that had been taken from Liechtenstein in 1946, etc., were shown at an exposition in, I think, somewhere in Germany. And so, of course, they went to the German courts, and they went to the Strasbourg Court of Human Rights, claiming that this is our property. It has been taken in breach of international law, and therefore it has to be restored, etc. And one of these claims was brought to the European Court of Human Rights in Strasbourg. But, you know, when you look at the European Court of Human Rights jurisprudence, you see that it has a device there, which, so I'm not a world expert on the Strasbourg law, but there is a principle that if an alleged or claimed human rights violation is committed, and there are some very cogent, very important policy considerations behind, or let's say international law considerations behind, then that human rights violation will just has to be accepted or tolerated. And that is precisely what happened with the Liechtenstein property. The European Court of Human Rights said, we have to see that these instances, these facts, date back to World War II, they date back to really high-level political problems and agreements after World War II, etc. And we have to respect that. So we are not going to in that and regard that painting that Liechtenstein claims belongs to it like a painting that was taken by the state of let's say Germany from somebody from a German owner, etc. So and this is something which you encounter actually in one of the cases also. At least in one of the cases that I mentioned, namely in the state immunity cases, like the Greek courts come to the conclusion there is a violation. Germany has violated. Germany doesn't really deserve immunity. Then they go to Strasbourg because the Greek state somehow suppresses that development. And I think Strasbourg decided more or less along the same lines like in the Liechtenstein case. They said this is World War II stuff, etc. And there are reasons for which we kind of give priority to these considerations, these high interstate diplomatic public international law considerations. They enjoy priority vis-a-vis the claims of the individual whose rights have been violated. I think that's as much as I can say just out of my cuff. And I hope this has been at least satisfactory to some degree. Since time is up, let me just say how much, I mean, pleasure is a matter of degree. And I have to say that my lectures to people physically present and sitting in front of me in Belo Horizonte 15 years ago were more pleasant. I remember there was a guy who looked at me all the time, and then I just asked him and said, "So what is there something wrong?" And then he showed me that he had on a piece of paper he had drawn a beautiful caricature of myself. Which was really very well done. And he said, well, you know, we are having great fun. So I don't know whether anybody has drawn a caricature, but unfortunately, I'll never be able to see it. So being together physically is, of course, different from just looking at a screen and not seeing you. But I think it's better than nothing. And I think this is really one of the very few positive effects of Corona. You can from my desk with my grandchild right behind, I can give you a lecture and you are in Brazil or in Myanmar or whatever. This is also wonderful. So it was a pleasure. I hope you found interesting what I said, and I wish you, let's say, happy life, great careers, and above all, watch out. Be very careful about the coronavirus, especially in Brazil. So take care, and obrigado.
Thank you very much, Professor Simma. I'm very grateful for your instigating lecture. Will be certainly generate much reflection for the students who see us. And of course, we come to the end of our lecture, and I would like to acknowledge the brilliant organization work done by Professor Leonardo Nemer and the CEDIM team on behalf of Paula Neves. Thanks to everyone, the audience, and especially thank you for the questions and for the attention. Bye. Bye, Professor Simma.
Bye-bye. Bye-bye.